Okay, so today I'm going to talk to you about the reason why we do this type of work, the ways that it positively impacts our clients. I also want to make sure that you can recognize the main methods of record sealing. So when you're talking to a potential client that needs record sealing or expungement, you can have a background about how that works, and then also be able to explain to clients what they can expect when going through the process and what we need from them to be able to help them with their record sealing. So as many of you may know, especially if you work in this community, having a criminal record can really hinder your opportunities and ability to fully access services and engage in everyday life. By being able to seal past criminal records, we are helping our clients be able to access safer and more stable housing, obtain work or obtain higher paying and more stable jobs, have greater access to education and loans, and just fully participate in the lives of their children and their families. Individuals that have criminal records can be prohibited from chaperoning their children's field trips, attending sporting events, things that you take for granted as being everyday activities that you involve yourself in. But by having a criminal record, you can be prohibited from doing those types of things. There is a difference between expungement and record sealing. For short, we do call our program the expungement program, but in reality, we are more of a record sealing program, and that is because of the laws in DC. In DC, expungement is very rare. Expungement acts as if the criminal record, as if the arrest or conviction never happened, and the information is removed from court and law enforcement records. As I mentioned, this is very rare. Only a few types of offenses qualify for this full expungement. However, many cases qualify for record sealing, and record sealing takes away the case from being accessible to the general public. This is huge for clients. Your typical employer, landlord are not going to be able to see those arrest records if they are sealed. They do remain available to several different agencies that I have listed here, including the courts, law enforcement agencies, including prosecutors, licensed school, daycares, educational facility, occupational licensing agencies, and then government employers, but only for senior positions like judicial nominating committees. So while those records are still accessible by several agencies, this type of record sealing is still very, very helpful for our clients, because your average person pulling a background check for a job, for housing, is not going to be able to see those arrest records any longer. There's something else in DC that can provide relief to our clients. It is called setting aside a conviction. This is typically most common under what is called the Youth Rehabilitation Act, which I'm going to get into more detail later on in the presentation. But this type of relief actually takes a conviction that a client received and sets it aside. It is as if the conviction never happened. This is a huge form of relief, and it is actually very common. The records themselves, the arrest record, the court records, would still exist once the conviction is set aside. But once the conviction is set aside, you can then seek to seal those other records. There are three ways in which to seal records that are the most common. And then, of course, our set aside convictions, which is going to be different than sealing of the records, but it is also pretty common. Our most common way that we seal records is under a statute that we call the interest of justice statute. Also, fugitive cases are very commonly sealed, as well as decriminalized or legalized cases. And I'm going to go through each of these in more detail. Some less common ways that records can be sealed but are still available under DC law. If an individual was arrested for a drug offense and they have no other prior offenses on their record, that single drug offense alone can be
Thank
sealed.
you for the bag. Okay, but I found my key. Oh, you found? Okay.
If someone is arrested for underage possession of alcohol, that can be sealed. If they pick up charges that were the result of them having been the victim of human trafficking. There's a separate statute in DC that allows those arrests to be sealed. And then there is also a statute that allows an individual to argue that they were actually innocent of the offenses for which they were arrested and they never should have been charged to begin with, and therefore those records should be sealed. The actual innocence cases only applies to cases where an individual was not convicted. If you were convicted, your relief for that type of argument would have been through an appeal. But if you were not convicted, you can argue to have your records sealed for that arrest and those cases under actual innocence. The interest of justice cases are our most common form of relief, and that is because under the DC law, the court shall, meaning it must, grant a motion to seal these records if it is in the interest of justice to do so. And what does that mean? The court has several factors that they must consider in determining whether or not to seal records under the interest of justice statute. That includes the interests of the movant, and the movant is our client, the community's interest in retaining access to those records, and the community's interest in furthering the movant's rehabilitation. The interest of our client is something that we are very good at arguing and being able to show the court that we want to improve our communities. We want to make them safer and more productive. And in order to do that, we need to seal our clients' records so that they're able to access jobs and housing and other services that are not available to them because they have a criminal record that is accessible to the public. The community's interest in furthering that rehabilitation is also something that we strongly focus on in these motions to seal their records. And so when you're talking to clients about needing to seal their records, anything that you can think that can go towards these factors to support our arguments is really helpful to provide the client to tell their attorney or to point out on their own if they're seeking to seal their records pro se. Being able to show that they have applied for jobs and they've been turned away because of their records. They've been given offer letters that have been withdrawn because then a background check is conducted. They've applied for housing and they've been turned away. Clients that have completed any sort of treatment or received services of certain kinds can be very helpful for the court in determining whether or not it's in the interest of justice to seal these past records. The biggest hurdle with sealing records under the interest of justice statute is that all cases and arrests that could be sealed under the interest of justice statute must be contained in one motion. You cannot file multiple motions. And there are waiting periods that clients have to get past before they are eligible to file a motion to seal these records. The waiting periods depend on the type of offense that they were initially arrested for, as well as the outcome of the case, whether or not there was a conviction or there was not a conviction. There are also called eligible and ineligible misdemeanor and felony offenses under this interest of justice statute. In DC, the definition for an eligible misdemeanor is quite literally any misdemeanor that is not an ineligible misdemeanor. There's a pretty lengthy list of ineligible misdemeanors that if anybody has a question about, we would be able to let them know whether or not they were charged with an eligible or ineligible misdemeanor. The most common are offenses that were charged as domestic violence and DUI offenses. All felonies that were convictions in the District of Columbia are considered ineligible to be sealed unless they were for failing to appear, which is also called the Bail Reform Act. That does not mean someone who is charged with a felony cannot have that sealed. If they were convicted, we may need to look and see how old they were when the offense was committed. If they were under a certain age, we may be able to set aside that conviction. Also, if they were arrested for a felony, but they were not convicted, those arrests and those records may be eligible to be sealed. So no one should be deterred based on what they believe they are eligible for on their arrest records. They should refer their arrest records to Rising for Justice, and we will review those and we will let them know based on the law what they are eligible for. Just so you have an idea of the waiting periods for different types of offenses under the interest of justice statute, if someone was charged with an eligible misdemeanor and that case did not result in a conviction, a lot of these cases are those no paper cases you may hear your clients talk about. That means they are arrested for something and the government decided not to prosecute the case. Clients believe that those were dismissed. They never went through the court system. They resolved very quickly. Even still, under current DC law, they have to wait 2 years before they can seek to seal those records. If they had any prior misdemeanor convictions, they would need to make sure that they had completed those cases at least 5 years ago. If they had any prior felony cases that were convictions, they would need to have completed the requirements for those at least 10 years ago. And they cannot have any pending cases in any jurisdiction, except for minor offenses, which tend to be traffic offenses. The no pending cases in any jurisdiction is a requirement for all motions to seal under the interest of justice statute, which can also make clients have to wait even longer if they have any open or pending cases. We're not going to be able to seal their other records until those cases have resolved under this statute. If a client was arrested for an ineligible misdemeanor that was not a conviction, or a felony that was not a conviction, depending on whether or not the case was actually papered or no papered, they would need to wait 3 or 4 years to file their motion to seal. And they will have needed to wait 5 years if they had a misdemeanor conviction and 10 years for any felony convictions to have completed. The client is arrested for an eligible misdemeanor, but they were convicted of that. They can seek to seal their records, as well as an eligible felony, which again is only the failure to appear. They need to wait 8 years after the conviction for the eligible misdemeanor or eligible felony has resolved, and they can never have been convicted of an ineligible misdemeanor or ineligible felony in any jurisdiction, and they cannot have any subsequent convictions for the offense that they are seeking to seal at that time. So no more recent convictions. As you can see, these timelines are lengthy and confusing, which is why having a lawyer to help our clients through this process is really important. Another way to seek sealing of records, if a client was charged with a fugitive from justice offense, that means that they were wanted on a warrant outside of the District of Columbia and they were arrested for it here in the district. They would have been charged with fugitive from justice. We can file motions to seal the records for those fugitive cases anytime. We don't have to wait. There's no waiting period to file this type of motion, and it can be filed more than once if they happen to have more than one. The requirement to be able to do this, and which puts the presumption that the court shall seal these records, if they can show that during the arrest for the fugitive from justice case, no other charges arose. They did not pick up any other charges during that arrest. They waived extradition, meaning they waived fighting going back to the jurisdiction that was wanting them, and they did appear in the jurisdiction that was wanting them for the underlying case. If they cannot show these 3 requirements, we can still seek to seal these records, but we would need to argue those interest of justice factors in doing so. This is a big one and something that's becoming more common. We can seek sealing of records for charges that someone was arrested for that have since been decriminalized or legalized. With the decriminalization and legalization of marijuana, we are able to seek sealing of those records, and we can do so at any time. There is no waiting period. These are very commonly granted. We just need to show that they were charged with possession. Possession with intent to distribute, unfortunately, does not qualify under this statute. But if they were charged with simple possession, then we can seek to seal those records at any time, as well as individuals charged with operating an unregistered vehicle and fare evasion. Failing to pay their metro fare, also a very common charge on people's records, and a lot of times those are no paper. We can seek to seal those at any time. Just some helpful information for you to know for clients. Depending on the age they were when they were arrested for possessing marijuana, changes the analysis as to whether or not it's considered legalized or decriminalized. And the difference on my end is there is a different analysis under the statute. If you were 21 and over when they possessed marijuana, that has been legalized. Under 21, it is being decriminalized. The Youth Rehabilitation Act, I mentioned this earlier. This is where we can take a conviction and set it aside, meaning the client is no longer to have been considered convicted of that offense. And then if it had been a felony offense, we can seek to actually seal those records. So this act really opens up record sealing relief for a lot of clients who otherwise would not be able to seek sealing of felony records. They don't have to be felonies, but this is what opens up a lot of felony relief. The offense must have occurred before the client turned 25. It only applies to offenses that resulted in a conviction because, again, the relief is setting aside the conviction. All offenses are eligible for this type of relief except for first and second degree murder, first and second degree sexual abuse, and first degree child abuse. So again, most offenses under the DC code are eligible for this type of relief as long as we can show that the client was under the age of 25 when the offense was committed and they were convicted. Once the conviction is set aside, we would then go back and file a motion to seal those records under the interest of justice to fully seal that case. I'm going to go through what to expect in the record sealing process when you work with Rising for Justice, and also just generally so that you have an idea of what to expect and you can explain this to clients. Unfortunately, the takeaway from this is going to be the process is pretty lengthy and there's a lot of timelines that unfortunately are out of our control. The first step in order for a Rising for Justice or a client to start working on sealing their record is they need to obtain their record from the police department. Unfortunately, the police department will not allow anyone to get the client's record except for themselves. We have tried, they will not allow anybody to do that. So clients need to do that themselves. And I'm going to go through some very specific instructions after the timeline to show you what the client needs to do to request that record. Once they have their record, we need to direct clients to call Rising for Justice. We will conduct an initial intake to make sure that they meet our grant requirements. Rising for Justice can represent DC residents looking to seal DC records, and they also have to be at or below 200% of the federal poverty line. Once we have the client's arrest record and we have verified that they meet our intake requirements, we will then review their arrest record. The arrest record review process involves more than just looking at the arrest record that the client provides us from the police department. Once we have that document, we then can go into the court's record system and look for any and all other cases that may appear and gather documentation to support our arguments to be able to seal the records that exist. We will conduct an eligibility determination, which determines what events on a client's record, what arrests, what cases, what convictions, if there are any, are eligible to be sealed. And we will explain that entire process to the client, explain to them what they are eligible for. If the client wants to work with Rising for Justice in sealing the records that we have determined are eligible, they would need to then sign a retainer agreement with us. We would have them participate in a full interview, and that would be conducted either by an attorney or an intern working with an attorney at Rising for Justice. This interview is lengthy. It takes about 45 minutes to an hour to complete, depending on how the client is feeling, and it is personal. The purpose of this interview is to get as much background information about the client as we can to be able to really thoroughly advocate for them in their motions to seal. At the end of the day, our goal is to convince the court that they should be sealing these records. And in order to do that on a personal level, we have to get personal with the client. Then once we've completed the interview process, the client's case will either be assigned to an attorney at Rising for Justice or a pro bono attorney. We work with attorneys at various law firms all over the district who want to volunteer to help us do this type of work. They want to help clients seal their records. And so they go through a training with myself, with Rising for Justice, on how to do this type of work, how to write the motions, what to expect, what the law is, so that they can do this work and assist us. And so a client's case may be assigned to a pro bono attorney. And if that's the case, we will make the introduction between the client and the pro bono attorney, and then the pro bono attorney would take over the case. We gather, as I mentioned before, information and documentation to support the motions. This may require the clients to sign some kind of releases for us to gather certain records that we cannot gather on our own. Once we have all of the information that we need to write the motions, we do that step. Once Rising for Justice or the pro bono attorney has drafted the motions to seal and they have been filed, the prosecuting agency that would have been or was on the other side of the case when it had been prosecuted, or would have been if it had been prosecuted, if it was no papered, they have an opportunity under the law to respond. They can either assent, and that is called a concession, or they can object, meaning they do not agree that the record should be sealed. There are times when the government files an objection that we can file a response to that. There's something that we can say back to the government and or the judge about what the objection was about to further argue our case. Sometimes it's not necessary. If it is, we'll do that as well. And then ultimately, once both sides are done filing their motions, the judge makes the decision whether or not to seal the records. As you can see, that's a pretty lengthy process. We let clients know that on average, from obtaining their record to getting the record sealed can take about 6 months. That is because once Rising for Justice has done all of the front end of the work and filed a motion, the government has 60 to 90 days to file their response. And they only have to file their response once the court issues an order for them to respond, which also takes time. And then once the government files their response, the court has to review everything, and that takes time. The majority of that time frame is spent with the government waiting to file their response and the court issuing its final orders. In order for us to get started on that process, we need clients to get their criminal records. There are different types of arrest records that clients can request from the police department, and we need to make sure that they get the correct one. It is the only record that will show no papered cases for our purposes to be able to include everything that possibly can be eligible to be sealed in our motions to seal. The type of record that they need to request is called an arrest record for the purposes of determining eligibility for sealing or expunging that record. It's lengthy. If they tell them they need the arrest record for purposes of sealing, that should get the job done. Unfortunately, there is also a cost to requesting these records. It is $7. The police department will not take personal checks. It has to be in the form of a money order. There can be It's supposed to be a wait of 10 days. That has unfortunately been much longer. Clients also need to bring identification, either a driver's license or a non-driver ID, or a birth certificate and their social security card. If they're bringing their birth certificate, they also need to bring their social security card. Otherwise, they can bring a driver's license or non-driver ID. You must be at least 18 years or older to request the record. You can only get a record about yourself. And since COVID, in order to obtain your arrest record, you have to make an appointment at the police department. In order to make that appointment, you have to do that online. This is where service providers can be very helpful in helping clients through this process, helping them get a money order for $7, helping them making sure they have their appropriate identification, helping them set the appointment. Unfortunately, what this results in is clients actually have to go to the police department twice. The first time you schedule an appointment to go in to request the record, and then they have to go back to pick up the record once it is ready. The alternative, we'll give you the information. The police department that they need to do this at is actually at the MPDC headquarters at 300 Indiana Avenue. They are open 9 to 5, Monday through Friday. The alternative is that clients can send in a notarized letter to request their record. It still needs to have that $7 money order payable to the DC treasurer. They need to also send in a self-addressed stamped envelope for them to return the record to. And the letter must include their full name, date of birth, social security number, and again, it must be notarized. Rising for Justice is more than willing to help clients drafting these letters. If service providers want to help clients get these letters out, we can send you a template letter so that you can have that to be able to help clients, whatever we can do to try to ease the process because it is quite burdensome. As I mentioned before, please refer any clients to Rising for Justice if they are DC residents looking to seal their DC records. And most clients, unfortunately meet our income requirements. So that's not usually the hurdle. We talked about those lengthy waiting periods. They are quite burdensome. But there are, changes to the law that are being argued and potentially going into effect, hopefully sooner than later. There has been a change in the DC expungement and record sealing law that has been approved. It has not yet been funded, and so we cannot file under the changed law. But people are advocating for changes to happen. And so clients should check back with us. If they're not eligible right now, we ask them to check back, in 6 months or a year to see if they're eligible at that point. I just want to put in a plug. Rising for Justice has been working really hard to expand our services. And one of our more recent developments is that we have full social work staff. We have a director of social worker. He has clinical social workers under him. We have social work interns. They are really looking to help as many people as we can that are Rising for Justice clients and the community. They can assist with employment resources, housing resources, childcare. If clients are looking for mental health services, substance use disorder services, they really want to start putting on some different groups and workshops. If you have any ideas for those types of services that clients are in need of, if you're hearing of certain types of programming that clients are looking for that they can't find, let us know. Our director of social work is an incredible human being, and he's really trying to get involved in the community. And then I'd be happy to take any questions. And my paralegal, Mary Helen, is also here to introduce herself. You can always call us, email us, stop by our office, whatever it takes. We really want to help as many people as we can.
Hello, everyone. I'm the paralegal for the programs. You can reach out to me if you have any questions, and I can connect you with some resources or some answers.